In the Idaho4 case, the judge has denied the request to end the non-dissemination order, aka the gag order, and has actually amended it, plus made a ruling on whether cameras should be allowed in the courtroom. Let's dive in. Hi everyone, Empowering True Crime, and we're talking today about the Idaho4 case. This is the sad, tragic killings of 4 University of Idaho students, November 13th, and currently the defendant is Bryan Kohberger. Trial is currently set actually for October, and so it's definitely coming up. I doubt it's going to actually happen, but because of that, there's a lot of things, a lot of motions that have happened over the last few months leading up to trial. One of those things was the gag order, the non-dissemination order. And there were 2 parties that were asking for amended non-dissemination order. The first is the AP group, is a group of media outlets that wanted to end the non-dissemination order. And so that was actually denied. And the judge put had a ruling on that, and there's a very lengthy report on that he wrote. And also the attorney for the Gonzalez family, Shannon Gray, also wanted to amend the non-dissemination order to allow him as the attorney, but he's more of a spokesperson for the Gonzalez family to be able to speak. Now, the Gonzalez family and all of the family members of the victims are allowed to speak. It's just their attorneys are not allowed to speak. And so that's what he wanted to amend that so to be allowed to be a spokesperson. That was denied as well. And the amended non-dissemination order was put out. Now, here's what's really interesting. Okay, I'm going to put a link here to the lawyer He actually goes through all of the documents from a legal standpoint. I am more of a media communications expert, which is why the gag order is very interesting to me. But because these are legal documents, he's going to go over those, and he did a really good job of that. I'll put the link there for you to review those if you want to go in depth into those. Very long documents. He doesn't go through the whole thing, all the documents, but he covers the main points. But in essence, those 2 parties were denied in the sense, no, the non-dissemination order is still in place, and the Gonzalez family attorney still is under the gag order or the non-dissemination order. So what's interesting is what the judge did decide to do is to amend it to be more clear about what would fall under the non-dissemination order, which the lawyer Peter Tragos, does talk about that as well. But I do want to talk about a few of those things. This was filed on June 23rd. And it says here, the court must attempt to balance the 6th Amendment right to a fair trial with the First Amendment rights to free speech and free press. To preserve the right to a fair trial, some curtailment of the dissemination of information in this case is necessary and authorized under the law. Therefore, the following is ordered. The prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys, and any attorneys representing witnesses, victims, or a victim's family are prohibited from making extrajudicial statements, written or oral, that the lawyer or agent knows or reasonably should know will have a substantial likelihood of materially prejudicing or otherwise influencing the outcome of the case. This order specifically prohibits any out-of-court statement which a reasonable person would expect to be disseminated by means of public communication that relates to the following: the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. Any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. The character, credibility, reputation, or criminal record of a party, victim, or witness, the identity of a witness, the expected testimony of a party, victim, or witness, the performance or results of an examination or test, or the refusal or failure of the defendant or a witness to submit to an examination or test. Any opinion as to the guilt or innocence of the defendant, the possibility of a plea of guilty to the offenses or any comment on any plea discussions, the existence of or contents of any confession, admission, or statement by the defendant, or the refusal of the defendant to make any statement, any information obtained by witnesses, the victims' families, or their attorneys from the state that is confidential and has not been publicly disclosed by the prosecuting attorneys. Attorneys involved in this case and their agents, as outlined in paragraph 1, may make extrajudicial statements, written or oral, concerning the following: the claim, offense, or defense involved, and except when prohibited by law, the identity of the parties involved, the information contained in the public record, that an investigation is ongoing, the scheduling or result of any step in the litigation. So it sounds like very procedural type things. A request for assistance from the public in obtaining evidence and information necessary to the state's case or the defense's case. A warning of danger concerning the behavior of a person involved, when there is reason to believe that there exists the likelihood of substantial harm to an individual to the public interest. The identity, residence, occupation, and family status of the accused, the fact, time, and place of arrest, the identity of investigating and arresting officers or agencies and the length of the investigation, and a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Any such statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. No individual covered by this revised amended non-dissemination order shall deliberately avoid its prescriptions by actions directly or indirectly that result in the violating this order, and this revised amended non-dissemination order shall remain in full force and effect until the conclusion of a trial and any sentencing proceedings that may follow unless otherwise ordered by this court. That was signed by Judge C. Judge on the 23rd of June. So he outlined in that non-dissemination order what can't be said, but then he also outlined what can be said. So that's what he wanted to do, is just be a little more helpful in the media and the agents understanding what they can and can't say. In addition, he made a statement about whether cameras can be allowed in the courtroom. And let's take a look at that real quick. And I'm not going to read all of this background, but I will just get right to the conclusion here. It says, given the high-profile nature of this case, the public's interest in watching what is happening in the courtroom, and Kohberger's fundamental right to a fair trial by an impartial jury, the court will reserve ruling on the issue of cameras in the courtroom. The court is faced with the difficult task of ensuring the proceedings are open to the public while also safeguarding Kohberger's right to a fair trial. The best way to continue to balance those interests is to revisit the issue of cameras in the courtroom as the case unfolds. This court has the discretion to either allow or disallow video recording of the proceedings. For now, cameras in the courtroom will continue to be allowed. However, that is subject to change by further order of this court. So basically, he's saying status quo, cameras will continue to be allowed for now, but don't test me, right? And so he also, there is another Idaho case, in the case of Lori Vallow, where cameras were allowed at first and then they were removed from the courtroom. So this, on the hearings that were, the motion hearing yesterday, he did discuss this, and I wanted to go over it with you guys.
I want to address, really everybody, about the revised.
Now it's funny because he's going to talk about cameras on the face, and it starts with a large part about Kohberger and showing his face. So that was interesting.
Amended dissemination order. Clearly, there's some misunderstanding about who it applies to and who it doesn't apply to. Because what I thought, and this is 100% my responsibility, I use the term agents, and the revised order says that the prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys are affected by this order. Apparently, some of the media interpreted that as it doesn't apply to law enforcement, but it does. So law enforcement they are agents of the prosecuting attorneys. Now, I'm going to issue another another revised order, just to make sure that that is clear, because people seem to be very confused about that. Agent, definition of an agent is one that acts or has the power or authority to act. Another definition is one empowered to act or represent another. So I'm going to include law enforcement or the prosecuting attorneys, agents, and for the defense attorneys, investigators. So it's clear. I think it's sort of doubling down on the definition, but apparently that's necessary. I'm also going to add retained expert witnesses for each side because we don't want to have a trial in the media or in the public. We want it to be in the courtroom. Speaking of that, a comment on the cameras. They're in the courtroom now. And I have deferred my decision about cameras. One of the things that's going to be really important, that is very important, is that the people with the camera and media need to follow the rules. And we've had some issues where people were pushing the envelope, particularly focusing on the tables where counsel sits. You are not to turn your cameras toward the top of those tables. And if you do that, you're probably going to have to leave the courtroom. Also, one of the things that happened in the Daybell case is that the cameras just continued to focus on the defendant. Don't do that. That's what brought the cameras to have to leave the courtroom in that case. And what I would prefer, if you want to continue to have cameras in this courtroom, is to back off and not. Do we have that? Yeah, make sure that's muted. Make sure that we just have the totality of what is happening in the court, and not just focus, for example, on Mr. Kohberger's case. So that was what happened in that case, and it's not appropriate.
So just to recap, he had to make a distinction that the non-dissemination order is not just for attorneys, but also for other agents like law enforcement, like, of course, the prosecution and all parties. He also said that he was going to add expert witnesses. So that would be really interesting as well, if they know who the expert witnesses are at this point. And so that was on the non-dissemination order. So he's going to amend the amended non-dissemination order to include that distinction, those distinctions. So since filming, this document was released by Judge, and it's the order clarifying the meaning of agents in the revised amended non-dissemination order. So it says on June 23rd, the court issued a revised amended non-dissemination order, and the accompanying the revised order were two lengthy opinions. The order denying Shannon Gray's request to be exempt from the amended non-dissemination order and granting requests that the order be clarified, and the order denying the Associated Press's motion to vacate the amended non-dissemination order. In this court's view, those opinions made clear that agents of attorneys involved in the case, including law enforcement, could have and would have their speech regulated under the revised amended non-dissemination order. However, following the issuance of those decisions in the revised order, the court took judicial notice of some news articles stating that law enforcement were no longer bound by the revised order. In an effort to clarify that misunderstanding, this court issues the following guidance. The revised order applies to, quote, the prosecuting attorneys, defense attorneys, and agents of the prosecuting attorneys and defense attorneys, and any attorneys representing witnesses, victims, or a victim's family. These individuals are not completely barred from speaking about the case, but must adhere to the restrictions on their speech imposed by the revised order. Agent is defined as someone who is authorized to act for or in place of another, a representative. Agents of the prosecuting attorneys include law enforcement working on this case or privy to confidential information involving the case. Similarly, investigators hired by the defense are agents of the defense. This is because those individuals are working at the direction of the attorneys to investigate the case, interview witnesses, and gather evidence. Stated differently, law enforcement and defense investigators are acting as representatives of the attorneys. The attorneys have the authority to direct certain actions of those individuals when it comes to building their case for trial. Other agents include staff in the prosecutors and defense attorneys' offices and expert witnesses. This order does not change anything in the revised order, but merely helps to further clarify who the revised order applies to. This is dated June 29th and signed by John C. Judge, District Judge. It's really kind of interesting that it was misconstrued that law enforcement was no longer included in that. I mean, I would think that would have just never changed. But not only has he made clear that law enforcement is included in the gag order or the non-dissemination order, but on top of that, now he's added other agents. And so he's making it actually, I would say, broader, but at least being specific on what can and can't be said. So hopefully this should clarify for everyone involved what is included in the non-dissemination order. And I'm sure if anyone has any questions, they'll go directly to the judge for clarification. And then also, as far as cameras, he said, reiterated again that it's kind of like he didn't make a decision as far as not allowing the cameras. He's going to leave it as is, but he was really clear. Don't focus on the different counsel tables. Don't focus on Kohberger's face. And he mentioned the Lori Vallow case in which they were focused on her and they were focused on her face. And so that's what made them restrict cameras or not allow cameras in the courtroom. And so he's like kind of giving a warning, like, hey, I don't want to have to do that. I'm just telling you what the rules are so that we can continue to have cameras in the courtroom. And, and even myself, I've been trying to be careful in what I say because it's tempting, but I'm going to be more mindful going forward in how I'm doing it because I don't want to be part of the body of media who is part of this incrimination of a defendant before, like he said, trial by media instead of in the courtroom. I don't want to contribute to that. I want to contribute to people having information and, of course, advocacy for the victims, but always being respectful of all the parties and just being mindful of that. So I would love to hear your thoughts. What do you think? Let me know in the comments. And if you enjoyed this video, if you learned something new, I'd appreciate it if you hit the thumbs up. And if you haven't yet subscribed to the Empowering family, join us and let's be the empowering voices for the voiceless missing persons, survivors, and victims. All right, everyone, stay safe, stay thriving, always follow your intuition, and remember to keep it empowering. Bye for now. Don't forget to like, subscribe, and hit the bell button for notifications. Thank you.